Go ahead and share the screen now. We're going to start with chapter 9. Okay, everyone. So you all should be seeing chapter 9, which deals with the Texas Judiciary here. All right. So we're going to be moving on to the last of the three major branches of Texas government. After we finish this chapter this week, next week we will move on to local government. And we will be able to finish off with the second unit here. Okay, so that's what we'll be working on for this week here. So, okay, so let's go ahead and delve into chapter 9, the Texas Judiciary here. So we're going to talk about, obviously, of course, we're going to talk about what the judiciary is. Obviously, of course, we're going to be talking about judges. We're also going to be talking about some aspects of the criminal justice system. But we're mostly going to be focusing on judges here. So by the end of this chapter, you should be able to discuss the judiciary as a political branch of government. We're going to talk about how, especially at the state level here in Texas, the judiciary branch definitely is regarded as a political branch because of the fact, for a lot of different reasons, but we'll start with the obvious fact that because judges in Texas are elected rather than appointed, they, by their very nature, are inherently part of the political system because they have to engage in the political system in order to get their job. So we'll talk about that interesting setup in Texas, which is, again, is a major difference from the federal judiciary, where in the federal judiciary, as we've mentioned before, the way federal judges get on the bench is through presidential appointments and then confirmations by the Senate. In Texas, judges are elected at all the different levels. All judges have to run for their seats. So we'll talk about how politics can play a role in judges wanting to get elected and keeping their positions. Describe the major players in the judicial system, including the central roles of the Attorney General, the bar, and lawyers in the process. We've talked a little bit about the Attorney General before. We'll also talk more about him in regards to and law enforcement / judicial aspect of the Attorney General here. Understand the structure of the Texas court system from the lowest courts to the 2 Supreme Courts. This is another major difference that we see when comparing the Texas court system to the federal court system. Whereas in the federal court system, we have one court of last resort, the U.S. Supreme Court. Texas, we have 2 Supreme Courts. We've got the Texas Supreme Court and the Texas Court of Criminal Appeals. So we'll look at both of those. Compare the roles of grand juries and trial juries. So most of you are probably familiar with what a trial jury is, but some of y'all, because that's typically when we think of juries, we think of trial juries, the juries that decide whether someone is guilty or not guilty. Basically, they close the case and they decide what someone's fate will be. But grand juries are also important. These happen before a trial even begins and they issue indictments. And so we'll talk about that here. And then evaluate major issues in the Texas judiciary, including problems with crime, problems with judicial selection, and issues of equality in the administration of justice. So we will talk about the public defender system and how we will talk about the public defender system and how there are some controversies when it comes to setting up a system of justice like this and whether justice is equally administered in Texas. Is justice blind? You've probably heard that phrase. You've probably seen the statue, right, where Lady Justice is, she's blindfolded, right, because she's not supposed to. All that extra stuff is not supposed to matter, right? It's not supposed to matter whether you're more rich than the other person. That justice is supposed to be blind for everyone. But is it actually like that? And one of the aspects that we'll look at is this idea of public defenders, and we'll look at how public defenders might, so if you're being represented by a public defender, you might not necessarily be receiving the same level of equal justice as opposed to maybe, someone who can afford a more expensive attorney. So we'll take a look at all those aspects here. Okay, but let's go ahead and start here. So then when we look at the judiciary, of course, the judiciary is defined as a collective term referring to the system of courts and its judges and other personnel, right? So of course, obviously, judges usually comprise the bulk of the understanding of the judiciary because when we think of courts, we always think of judges, right? But we're also going to talk about how judges are not the only people that are involved in the judicial system, right? We've also got other people at work, right? We've got bailiffs, we've got the stenographers, right? We also have those are the people that work there for the court, right? We've also got the clerks who are responsible for the paper pushing and the documentation. And of course, we also have the district attorneys, right? We've got the prosecutors who prosecute these criminal cases, and of course, we also have the defense attorneys that will defend people against these these accusations, and we have the jury in a lot of these cases to determine whether someone is guilty or not guilty. So all of that, of course, is considered part of the judiciary. You could also consider like the criminal justice system also as a kind of like, that's more so on the enforcement side, but you can also see how maybe like parole officers can also be somewhat considered kind of like hybrid, so to speak, because they've already been in prison and now they were let out early, or let's say they're on probation where they avoided prison time, then they also have to check into these probation officers, things like that. So there's other personnel that also are involved in the criminal justice system, right? So, and of course, one of the major questions we're going to take a look at in this chapter is, are judges part of the political process or not? And if they are, how can they be installed in office in a manner that ensures that they will be fair and impartial, but still accountable to the public? Because, and we will talk about this here as we go through the chapter, right? That and it's not a right or wrong thing, in terms of having a judicial system where judges are appointed and they serve those life appointments, as opposed to having, that's what we have at the federal level, as opposed to in Texas where we have elected judges who are accountable to the public, yet, and they're accountable to the public because they have to seek the public's the public's approval in order to maintain that office. But can they be fair and impartial if they are seeking approval from the public, right? We'll talk about, one of the major issues, and there's a good video that I have here in the class. It's an old 60 Minutes interview from 1987. So it is dated in terms of its quality and things like that. But what's important, and I want you all to definitely take some time to watch this, is I want you all to see how that there is the controversy where if you have judges who are running for elective office, what happens to attorneys who have business with a judge? Like, what I mean by this is, let's say there are attorneys that have cases with that specific judge. Would it be a conflict of interest to donate to this judge's reelection campaign? I want for the wheels to start turning in your mind as you're thinking about this, right? Imagine, like I said, you're this attorney, you've got this pending case with this judge. Would it be ethical to donate to that judge? These are things that I want for y'all to think about when it comes to the elective system for judges, right? And so they're definitely watch that 60 Minutes video, and it is really eye-opening to see some of that stuff. It's one of my favorite resources that I like to use in my Texas government class. I do need to download that video in case it ever gets pulled, because I don't think I would ever be able to find it again. Okay, but anyway, so with that being said, let's talk about the myth of the non-political judiciary, right? So when we think of the mythos of judges, right? I mean, I think some of you all are familiar with what I'm talking about. We tend to regard judges as, non-political, impartial, and incorruptible because we hold them in such high regard, right? They have the black robes. Whenever they walk in, you have the bailiff that says "All rise for honorable judge," so and so, whatever. There's all that respect that goes into being a judge, right? They have a lot of respect within society. The way attorneys and people talk to them, they'll say like "Your Honor," like I always, one of my uncles is a district judge, and so of course obviously he's family, but it's interesting to see, how and I call him sir, because just out of respect, and things like that, because I hold high respect for him, as being one of our most one of our most I guess you could say most accomplished family members. So obviously, of course, there does come that respect. But the thing is that we have to keep in mind that is that really how it is, right? Are judges supposed to be above everything? Do they have this overwhelming sense of wisdom going back to the BC era when we had the Code of Hammurabi, and we had even going back to the Bible, and how the idea of judges and someone being in high authority with high wisdom, and being able to make these impartial decisions, and that they can't be influenced by outside influences, things like that. That's what we think of when we think of judges, right? However, we do have to look at this a little bit more logistically, right, and more logically in terms of is this really how judges are, right? So let's take a look at judicial interpretation. So it is more political in elected systems. What the book is talking about is that in systems where judges do have to run as members of a political party, and we will talk about political parties later on when I'm not sure if it's before Thanksgiving or after Thanksgiving, but we will get to them very soon. the idea is that if you have, or the evidence points that if you have a judge that has to run as a under the political moniker, right? What I mean by that is that do they run with an R or a D next to their name? They are going to be, they do tend to be more political in terms of the decisions that they make. That it can be more politically influenced as opposed to judges who are appointed. But even then, there's also research that points that certain judges that are appointed by certain presidents will be they not all the time. What I mean by this is that if, let's say, you have President Trump, back then he appointed 3 judges, right, to the Supreme Court, right? He appointed Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, right? So there's a reason why former President Trump appointed those judges, right? Because he wanted judges to be more like constitutionalists, more judicial restraint. That basically means where they look at the Constitution more literally, and they derive their judicial philosophies and their jurisprudence strictly from what the Constitution is saying. And then on the other side, like President Obama, he appointed Elena Kagan and Sonia Sotomayor. Those are judges that are more, they subscribe more to judicial activism, where maybe they look beyond the text of the original Constitution and kind of adapt it to modern times and how society has progressed and things like that. So again, there's no right or wrong way to view this. It's just that the point I'm trying to make is that there sometimes is that correlation. A lot of times there is that correlation between the political party of the president and the judges that are appointed. So that is evident in those appointee systems. But the book says that it's even more evident when those judges are political themselves, when they actually are full-fledged members of political parties and they're actually running in these political systems here. And so parties, of course, can also still disagree with one another. One of the examples, within these ideological divisions was the abortion case of 2000. This was an interesting case where you had Texas had passed an abortion law at this time where, and of course, this is outdated before the Hobbs case, which had overturned Roe versus Wade. But let's think back to when Roe versus Wade was still around. This case involved a statute that had been passed by the Texas legislature, which had made it to where if you had underage women that were wanting to get an abortion, they would need to get parental approval, right? Their parents would have to approve it. This could be waived, though, if one of these underage women, if she was able to go and get approval from a state judge. Okay, so you had a situation where one of these women did go to a state judge. The state judge did not approve for the abortion, because the idea was that the judge would approve it if the judge felt that the underage woman was of the right state of mind, was wise enough and smart enough to make their own decisions. So this underage woman disagreed with the judge's assertion that she was not, wise enough to make that decision. So, the underage woman, she took it up to the Texas Supreme Court, and the Texas Supreme Court overturned the previous judge's decision to say that yes, she could get an abortion. So there was disagreement on this, even within, members of the same Texas the same Texas Supreme Court. But and again, also keep in mind that this was in 2000. It might be, I don't know how the court would rule this more today, although that's kind of moot because, again, we have Roe versus Wade that's been overturned. But I just want to mention that even within the same ideological factions, you can still have disagreements here. And so politicians in black robes bound by canons of ethics and standards of judicial procedure. So this is also important that we also have to keep in mind, right? And that's why that video that I want you all to watch is going to be very important, because it does talk about the Texas Commission on Judicial Conduct. This is a commission that is run by the Texas legislature that investigates allegations of judges engaging in violations of their canons of ethics, right? So judges are held to these ethics that they are supposed to adhere to, and if there are violations of those ethics, then complaints can be filed with the Texas Commission on Judicial Conduct. But we'll talk about that a little bit later. And so on a day-to-day basis, most judges would apply issues in the law the same, no matter their political leaning. So so the idea is that, and let me kind of explain this a little bit better. So you also have to keep in mind that not every judge, in terms of the level that they're at, is going to be dealing with political issues within their cases, right? So the Supreme Court, by its very nature, you could make a strong argument that the Supreme Court is somewhat political, because they decide on political decisions, right? The decision to overturn Roe versus Wade is a very political issue, right? Because you are engaging in crafting case law that then has to be followed throughout the country, right? I think you all are aware of that, right? That the reason why we pay attention to the Supreme Court is because when the Supreme Court makes a decision, that becomes binding case law, right? There's not a law out there that bans abortion, but we have a Supreme Court case that has overturned Roe versus Wade, right? So that's why abortion is now no longer, is no longer protected as a right in this country because of the Supreme Court's ruling, right? So that's the way, so that's one of the ways that that's one of the ways that laws can happen is through the Supreme Court and their interpretation of law, right? So that builds on the case law. So the point I'm trying to make with this is that situation definitely is very political. But let's say you've got a justice of the peace judge who is deciding whether this person who defaulted on their credit card, whether they need to pay it or not. There's probably not a need to make a major political statement in that case, right? Because it's very mundane, it's just very matter of fact, it's just a little bit of money. So does that kind of make sense in terms of how that most judges would apply the issues in the law the same, no matter their political leaning? So that justice of the peace could very well maybe feel that that the company shouldn't be like preying on people or whatever. That could be their own political viewpoints, but the judge is not going to go make an example out of these people because it's a small amount and there's no, it's not really going to get you anywhere, right? So also keep in mind that the lower level judges are probably going to be less likely to engage in these types of political statements because the nature of the case doesn't lend itself to become outright political. I hope that makes sense in terms of what I'm trying to explain here. Now, let's talk about the Attorney General, right? And of course, we've mentioned Ken Paxton quite a bit in our discussions here, and there is of course more. There is going to be some more. What's the word I'm looking for? There's going to be some more spillover here in this class because, of course, we're dealing with the Texas Judiciary, right? So, of course, we know that the Attorney General is an independently elected executive. They are part of the parole executive here, and the Attorney General is Texas's chief lawyer, right? So the chief, the top-ranking lawyer, the top-ranking law enforcement official here within Texas. They represent the state in court. Right? Remember we talked about this last time, right? We talked about how that whenever the state of Texas gets sued, that the Attorney General is going to, and of course it also depends on who's doing the suing, right? If it's the United States suing Texas, then yeah, of course it's going to be on all hands on deck. And as I like to mention, that usually happens more often than people might think. But yes, if you've got, like, let's say, like the lawsuit that's going on in Eagle Pass with the buoys in the middle of the Rio Grande, that obviously, of course, is in federal court with the United States, suing Texas on that. So obviously, of course, Ken Paxton is going to be, is going to be the chief administrator of that case on the Texas side because it doesn't get bigger than being sued by the federal government, right? So of course that'll be, Ken Paxton will definitely take the lead on that case here, right? So again, represents the state in court, and usually the more high profile and higher level cases that the Texas is involved in, that'll be more likely that the Attorney General will get involved, and the power to also issue advisory opinions. And we talked about this, right? We talked about how an advisory opinion is where the Attorney General will take a look at laws and they will decide whether that law is constitutional, right? Whether it aligns with with the state constitution. And if it doesn't, then the Attorney General can make a ruling on that, basically saying that, you know what, don't even bother with this case because my interpretation is that it's unconstitutional. So if you pass it, it's going to get struck down later on by the courts. So might as well don't even do that. And of course, that is that is something that can be very powerful because it can save time in terms of crafting legislation that's going to be struck down later on anyway, right? So that is a very important aspect here, to where the Attorney General can give that advisory opinion, and then the legislature can follow suit with it. Now, we also want to talk a little bit about some of these affirmative action cases, such as the Hopwood case. There was also the other case was the Fisher versus University of Texas. So the Hopwood and the Fisher case, these two cases deal with the aspect of affirmative action. Now, affirmative action, if you remember this from federal government, this is a policy that was popularized during the American Civil Rights Movement. Certainly with the Civil Rights Act of 1965 definitely gave some teeth to this, where businesses entities, colleges, universities, anyone who is doing, who is engaged in whether it's business or academic practices, would be subjected to the Civil Rights Acts of 1965. We also have Title IX with the 1972 Educational Amendments that also builds on the Civil Rights Act. And basically, what all this means is that the idea of affirmative action was being codified into these types of legislation and of subsequent Supreme Court cases, which strengthened them. The idea was that you wanted to create a situation where minorities would have more of an equal chance to be able to get into colleges, especially like some of these prestigious colleges, which we'll talk about here in a bit, get into some of these high-paying jobs, be able to move up within society. Because, if we go back to before the American Civil Rights Movement, you had situations where employers could outright discriminate against minorities and say, you know what, I'm not going to hire that African American, I'm not going to hire that Hispanic, I'm not going to hire that Asian American simply because of the basis of their race or even gender, right? I'm not going to hire that one. So the American Civil Rights Movement put a stop to that, to where you could not discriminate against people that way, right? You could not just simply not hire someone simply on, the basis of race, gender, religion, age is another one, right? So we have all of these provisions, right? If you all have ever filled out a job application, are you all familiar with that wordage at the bottom of the application where it says, "We, whoever, do not discriminate on the basis of race, sex, gender"? All of that was put in there because of the American Civil Rights Movement and the and the Civil Rights Act. I'm sorry, of 1960. I'm sorry, the 1964. 65 was the Voting Rights Act. My bad. I apologize. So 64 was the Civil Rights Act. So with that being said, of course, now we have legislation that has strengthened that, as well as Supreme Court cases that have also strengthened that. But we do have a couple of cases that did come out of Texas, right? So both of these cases involve white students who were trying to get into law school, right? So the Hopwood case, this was a situation where and both of them were for UT Law School. So you had situations where you had these white students who were not being admitted into the UT Austin Law School. And the problem with these cases was that these students definitely did their due diligence. And I'm thinking to myself, yeah, I would probably do this if I was them. So I don't fault them for doing this. What they did was they looked at who got in, and they compared their GPA to the students who got in compared to them. And there were some cases where some of the students who got in had lower GPAs than this white student, but they got in because they were minorities. So they were making the argument that, hey, we're being reversely discriminated against here. And the Texas Supreme Court did rule, I'm sorry, the U.S. Supreme Court, because it did get to the U.S. Supreme Court, sorry. The U.S. Supreme Court did rule that, yes, that this, you can't reverse discriminate against people. You can have diversity, not necessarily quotas, but you can make diversity part of the, admissions process, but it can't be the only thing, right? It has to be done more holistically, right? You have to look at everything, not just whether someone, is a minority or not. You have to also look at their academic accomplishments. You also have to look at their, what they did in undergrad and in high school, right? The organizations they volunteered on, community service that they did, right? All of that goes into the decision whether to admit someone into one of these prestigious law schools, right? Because UT Austin is probably regarded as one of the most prestigious, if not the most prestigious law school in the state. So you can tell it's definitely very competitive. So the Supreme Court basically ruled that the affirmative action cannot go so far, right? You cannot make it to where you're going to discriminate against white people simply because you need to meet a certain quota for minorities, right? You definitely want to have those minorities, be allowed to be able to go, and you want to try to have a good mix of minorities and white people as well. But it has to be, it can't just be, you can't just discriminate against white people. And of course, also more recently, we've seen in the last couple of months here, we've seen the state of Texas. I don't know if you all heard of this in the news. There was this decision to kind of roll back some of these diversity programs, like at colleges and universities, where now the state wasn't going to be so strict about maintaining those minority programs, to try to hire more minority people in colleges and universities, try to accept more minority people. So there also has been a little bit of rollback at the state level on this as well here. Okay, so that's in a nutshell what the Hopwood and the Fisher case here. Again, both of them dealing with UT Austin Law School. Okay, so hopefully that makes sense in terms of the issue, right? That you can't just the issue. Let me sum up the issue again, right? The issue was that if you're going to admit people into a law school, you can't just have like racial quotas. You have to do it more holistically, right? Where yes, you look at race and ethnicity and gender as part of the process, but that can't be the only way you look at it, right? You have to look at other things, right? And you have to do it in more. You have to the application process has to be in a more holistic manner, right? Basically, where you take more things into consideration. Okay, let's take a look at lawyers here. Okay, so if any of you are interested in being attorneys, lawyers, the same thing, but they have different names here. This is definitely the chapter for you. I think I mentioned to you all before that I'm interested in probably going to law school. It was something I wanted to do when I was younger, but then I started teaching and I wasn't able to do so. I know that Sussex College of Law has just started um, an online law school, and I might be interested in doing that in the future. I need to get my PhD in political science first, but I might consider doing law school because I kind of want to do law on the side. Probably not right now because it's hard to be an attorney and be a full-time professor, but maybe when I retire, it might be something I might do on the side, just for something to do. But anyway, so let's take a look at the requirements. Okay, now, in order to be a lawyer in Texas, so you definitely do have to go to law school, right? You can't escape that, right? It's not the old days like where Abraham Lincoln just kind of self-taught himself to become an attorney, right? You want to be a lawyer in Texas, you have to go to law school. So the way it works is you have to, and depending on the types of law schools that are out there in Texas, like I said, some of them are more prestigious, like UT Austin, Texas A&M. Those, of course, are going to be more competitive and more prestigious. Um, these law schools, what they do is they also make it mandatory for you to take one of these standardized tests. It's called the LSAT. It's basically like the lawyer version of the GRE. I've taken the GRE a couple times, I've never taken the LSAT, but I've heard that the LSAT, like I said, is very similar to the GRE. So it's kind of like if you've ever taken that test, it's basically like it's they're trying to test your logic and reasoning. It's not necessarily a test about knowledge that you study for. It's more so like scenarios. Like an example would be like, and of course they also do math in the GRE. I don't know about the LSAT, but I know that for for the standardized tests, what they'll do is they'll ask you like some comparison words. Like an example would be um I don't know, like is to love as dislike is to hate, some of that. You know what I mean? Like something like that. Like they do those types of those word comparison types of it's almost like riddles, I guess you could say. But there's those types of questions, like logic and reasoning to try to gauge, how well your logical reason your logical skills are, type of thing. So you practice for that, you study for that, you take the LSAT. If you do well on the LSAT as well as your undergraduate and your other schooling, then you can be admitted to law school, right? So then of course you go and take your law school classes. Like I said, the other day I was kind of looking at the degree plan for law school, and there's all kinds of classes. There's classes on contracts. There's classes on constitutional law. So again, depending on which type of law you want to practice, you want to focus more on civil law and lawsuits, or you want to focus more on criminal defense, or maybe you want to be like work for the district attorney one day. So maybe you could focus on prosecutorial law, things like that. So they do make you take all those classes, so that way you're well versed, but you can also specialize in some things, which is no different than like the PhD I'm working on, right? Like for my government PhD I'm working on, I'm specializing in American government, which makes sense because that's what I teach. But my secondary area is comparative politics, so that's where I'm going to take classes like the Middle East, Middle Eastern politics, and of course that'll be interesting with what's been going on here in the Middle East so far. But yeah, so I have that specialization. So then you pass your law school classes, then you in order to get your law degree, you have to pass the state bar exam, which again, no different than like passing your comps. It is different. It's harder, but usually these graduate programs will have some sort of final exam that you have to pass, right, in order to ensure that you have definitely know the knowledge and skills that are required from this degree. So then you pass the state bar, you receive and maintain your law license. You have to submit that application to the Texas Supreme Court, because we're talking about how the Texas Supreme Court is responsible for overseeing the law schools in Texas and also constructing the state bar test, right? So the Texas Supreme Court is responsible for certifying attorneys here. And then, and of course, like we said, requires a law degree in order to be eligible to do this in the first place. Now, here's another interesting aspect. The Texas State Bar. This is an organization that is both a government agency and an influential professional association that lobbies government on behalf of its members. So this is an interesting quirk that every attorney in Texas has to be a member of the Texas State Bar. So you have to maintain that membership in order to be able to maintain your ability to be a practicing attorney in Texas, right? So again, they are a government agency because they are responsible, like I said, and the Texas State Bar is overseen by the Texas Supreme Court. They are responsible for certifying attorneys and ensuring, and also what they also do is that they also review the law schools, right? They ensure that the law schools are teaching the standards that are necessary for attorneys to be able to actually know their stuff and be successful as attorneys out in the field. So they do evaluate the law schools. They get it. Texas State Bar accredits the law schools. And like I said, they also set up the State Bar tests. So that's one aspect. But it's also a professional association because, like we said, that all the attorneys in Texas are members of this organization. So you can imagine that this is a very powerful group. This might be the most powerful group in Texas because it's a group that has all the lawyers, right? And all the lawyers, of course, they know the law, right? And so you definitely don't want to mess with those types of people because of what they know, right? So having an association that has all of them, you can imagine the type of power and influence they have. Plus, also keep in mind that a lot of these state legislators and state senators, they're also practicing attorneys as well. So that also can also impact how powerful they can be as well. So just keep that in mind also. Okay, let's see. So we've got about 10 minutes left. Let's see. Maybe we can get to this. But I definitely do want to. I definitely don't want to. Let's see. Okay, so I definitely wanted to, because I know that that'll probably take a little bit of time here. Because maybe we could skip over and then we could come back to it. Yeah, the court system is probably going to take a while, so I don't want to get started on it until next time here. So yeah, let me see if we can talk a little bit about the some of this other stuff, right? Yeah, let's see. Give me just a moment. Let's see. Let me just get something else to drink and then a drink of water, and then we'll yeah, we can talk about juries and the police right now, and then we can pick up on the rest of this next time. Yeah. So let's go ahead and talk about these two, and then I'll pick on the next time. Give me just a moment. Let me just get a little bit of water here, and I'll be right back. Okay, everyone, sorry about that. Okay, yeah. So we got about a little less than 10 minutes. So let's go ahead and finish up on these two, and then we should finish for today. And then we'll start on the actual Texas court system here next time. Okay, so let's talk about juries here. Okay, now, as I was mentioning at the beginning here, there are two types of juries that we have in the criminal justice system. Okay, so we got grand juries and trial juries. Now, let's start with trial juries because trial juries are the ones that you're probably most aware of, right? So trial juries, of course, determine the legal guilt or innocence of defendants in a criminal trial or the liability of defendants in a civil trial, right? Now, this is something that is a little bit of a, I don't necessarily want to say it's a pet peeve of mine, but this is something that I learned from one of my criminal justice professors. He doesn't necessarily like to use the word innocent because that implies that the defendant didn't do this 100%. So he liked to use the terms guilty or not guilty because keep in mind that in our criminal justice system, that the burden of proof is on the government, on the prosecution to prove whether someone is guilty of a crime or not, right? So just because someone is found to be not guilty doesn't necessarily mean that they didn't do it. I mean, everyone is pretty much convinced that O.J. Simpson probably engaged in, he did what he did, right? If you're familiar with the O.J. Simpson case, you'll know what I'm talking about. But he was found to be not guilty because there was some reasonable doubt by the jury, right? Because the idea is that they have to prove beyond a reasonable doubt, right? That's the standard of proof that's needed in order to determine whether someone is guilty or not guilty, right? So if they can't meet that standard, and that standard doesn't necessarily mean that they know for a fact that they didn't do it. It could just also mean that they're not sure. So if the jury's not sure, if they don't know, then the default has to be not guilty because the burden of proof is on the government. The government has to prove. It's not the other way around where you're guilty until proven innocent, right? Like we have in some of these other countries, right? In the United States, we have innocent until proven guilty. So if the government doesn't do a good enough job proving to the jury that they did this, then they have to go free because that's the system that we have. And so in the lower court, and also keep in mind that we also have trial juries, not just for criminal cases, but also for civil cases, right? Now, in a civil case, it's much easier to prove whether someone was liable. That's called preponderance of the evidence. That's why in the O.J. Simpson case, that's why he was found to be not guilty in the criminal case. But then he got sued by Ron Goldman's family, and he was found to be guilty, or I'm sorry, liable, in that sense. And that's why he had to pay off all that money to the Goldman family. That's why he had to sell his Heisman Trophy, and he tried to get it back. And then, of course, he was arrested for that in Las Vegas. And so it's a whole other story. But okay, so with that being said, when we look at the lower courts, they have a jury of 6, and in a district court they have a jury of 12. And in Texas, defendants in civil cases and anyone charged with a crime may demand a trial by jury, right? Because again, this is we have that retro trial by jury within our U.S. Constitution. Now, also keep in mind, everyone, that I don't know if any of y'all have served on a jury before. I know I have, and the interesting thing about going to jury duty is I know a lot of people don't like it, although I do find it interesting. Do keep in mind that in order to serve on a jury, there is a process that happens. Yes, you have all these people show up, but not everyone who shows up on that day of jury duty actually gets called to actually serve on jury. What they'll do is they send the jury summons. Let's see, there's someone in the chat saying something. You were summoned to testify, wasn't it? Okay, actually, so you've been through this process, right? Yeah, it's not. I know, like for me, like now for me, it's interesting because like I get paid from work. Like I have that. I do get like time off from work, but I know not everyone has that luxury, right? So I know for me it's cool because it's kind of like a day off from work. And they do have to honor that, right? Like the work can't say no. Like you have to come in. No, because they can't violate that court summons, right? So right, so you probably know what I'm talking about. Right? You go in that big room, and then they show you like the video, and then they have a judge there that will they have the judge there so where you can make requests if like to be excused. Usually some of those excuses will be like if let's say you're the primary caretaker of a child, or let's say you're in college, you can also be excused. That doesn't mean that that doesn't mean that you have to be excused, right? You can choose to serve if you want to, but you can use that as an excuse, right? And then what they do then after they've gotten all the excuses out of the way, then they will then you'll have representatives from the different courts, because the reason why they have so many people to show up is because there's a bunch of courts that need people, right? So let's say there's like 10 courts. So then they'll divide up the room, like, okay, like you 24 people, go to this court at this time. You're going to meet at this court like tomorrow at 8 a.m. or something like that, right? So they do that, right? They tell you what court you're going to go to and at what time. Then you get there, and then what they'll do is you'll have a situation which is called, or a procedure which is called the voir dire process. This is where you have the prosecution and the defense. What they will do is they will ask the jury's questions, right? Because if it's a lower court, it goes down to 6. If it's a district court, it goes down to 12, right? So let's say we're in a district court, right? There's 24 of us, and they need to whittle it down to 12. What they'll do in the voir dire process is they will ask the jury members questions. The first question they usually ask is, okay, members of the jury, do you know anyone in this courtroom? Now, let me ask you all this question. Why do you think it would be important for the prosecution and the defense attorneys to ask the jury, the potential jurors, if they know anyone in that courtroom? Like, let's say they know the judge, or let's say they know the defendant, right? Let's say the defendant is one of your cousins, right? Are you going to be able to judge your cousin fairly if they're a family member? Like, kind of think about this, right? And I think you all probably know the answer to this, right? So it makes sense for them to ask those questions, because if you know anyone personally, it's going to be hard for you to be able to judge them. Other questions would be like, they'll ask the jury if like, hey, like, what do you all think about police? Do you trust the police? Do you not trust the police? So if you've got someone who says that they don't trust the police, then they're also not going to be able to serve, because the police are probably going to be a big part of the testimony process, right? They're going to be called to testify, and also evidence is going to be provided by the police, right? Or let's say it's a death penalty sentencing case. Obviously, of course, they're going to ask the jury if anyone is against the death penalty, and if you are, then you're not going to be able to serve, right? So do keep in mind, this is the way the trial juries operate, right? And then once they ask their questions, then they'll have their 12, and then they'll go through and then of course they'll actually start with the trial process, and then the jury will decide whether someone's guilty or not guilty, and it does have to be unanimous, right? And so they'll deliberate and then they'll decide whether someone is guilty or not guilty. Okay, so that's the trial juries. Now, grand juries happen before a trial even begins. This is a legal body of 12 or more individuals convened at the county seat. Now, I used to work at the district clerk's office, so I've gone and I have gotten like information from the grand jury to then bring over to the court, to whether it was an indictment or not. And so the considers the evidence submitted by prosecutors and determines what. So all I did was the paper pusher, though. I wasn't actually like involved in the process. I just took the actual document, right? And then I brought it over to the court here. So considers evidence submitted by prosecutors and determines whether there is sufficient evidence to indict officially accused those accused of crimes, right? So the way the grand jury process works is you have the district attorneys, the prosecutors, they're providing evidence to this grand jury, and then the grand jury will determine whether that's enough evidence to formally indict someone, accuse someone of crimes, and have them brought before the court, right, to answer to those crimes. Selected by jury commissioners, 3 to 5 persons, selected by a district judge. So this determines who's going to serve on the grand jury. Usually, this deals with felony cases. Criticized for almost always acting in accordance with the prosecutor's wishes. So yeah, there are some criticisms in terms of how that the grand juries don't really have a lot of freedom to ask questions or to ask for further documentation. They just they're only given what the prosecution gives to them, and it does become a situation where the grand jury might not be able to be allowed to be able to kind of go against what the prosecutors are because the prosecutors have, because again, you don't have the other side to answer to that, right? You're just kind of hearing it from the prosecutor's side, so it does create a situation where that might create some recency bias because you're only hearing that one side. So, but okay, let's go ahead and stop here for today. Let me go ahead and stop the share, stop the video here.